Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. We're delighted to welcome back attorney Andrew M. Lieb, who's going to talk about ethics concerning real estate brokers. This program is applicable to the general public who wants to know about real estate, of course, real estate brokers, and lawyers who have to deal with real estate brokers. Lawyers can also earn CLE credit by listening to this program. Just listen for the code at the end of the show. Andrew, welcome back to Law You Should Know.
Thanks, Ken. I'm thrilled to be getting CLE credit myself, so I'm very happy to be here.
And I should mention, Andrew also runs training courses for real estate brokers, one-on-one or to large real estate firms, and also teaches their continuing education courses. So just start us out by what are the sources of ethics for real estate brokers?
So in simplest terms, it's Article 12A of the Real Property Law, which is their body of law. But for the listener, the easiest thing to do, we live in the Empire State. So in the Empire State, all you have to do is you have to Google real estate license law. And the first thing that comes up is the real estate license law, and that's all the ethics rules.
Among other rules.
Well, it's a lot of rules, but they're all considered to be, when you say ethics rules, just to be clear about that, everything derives off of 19 New York Code of Rules and Regulations, Part 175, and everything derives also off of the Article 12A of the Real Property Law.
And what are some of the we'll go through them in detail, sort of chronologically, but what are some of the issues they cover? The
two biggest topics, you mentioned I teach continuing ed. There's only two required topics in continuing ed, so those are the two biggest. The first one is agency, and the second one is fair housing and discrimination. And throughout the United States, particularly New York, discrimination is the number one topic today.
Okay, and we will come to that later in the program, and this program is one of two parts. So let's talk about at the beginning of a transaction. What types of ethics are there by the brokers in soliciting the clients, or what can they do and cannot do to solicit clients?
So not only is your question good, but it's timely. Because last week, the Board of Real Estate in the state of New York met and they discussed modifying the advertising regulations. But as of today, you'd find the advertising regulations at 19 New York Code of Rules and Regulations, Part 175.25. And there's a plethora of rules. Let's start off with the simplest one. You have to identify that you're licensed and what your license is.
And in soliciting sellers to list with them, what can they do or not do, and to encourage them to sign the agreement or pressure them to sign the listing agreement?
Let's start off with what they can't do.
Okay.
So the most interesting, I think, of the regulations is 19 NYCR 175.8, which says that you can't directly negotiate with a party that has an exclusive with another company. In brokerage, a big thing, and I'm not sure anyone who's selling their house knows, that when you didn't sell, every broker comes out like a piranha to try and get your listing.
So they really should ask you first, have you listed with anyone else?
Not only should they ask, but they would know themselves from just looking on the MLS system. And if they contact you while you have a listing with another company, that's an ethics violation.
Okay. Does that happen anyway?
It happens all the time. And I'll tell you where the problem arises. Broker A, who's frustrated that they invested in the property and tried to sell it, who didn't, finds out that broker B tries to solicit and poach their listing. One could argue that's tortious interference with a contract as well, and broker B complains to the Department of State, who brings a license violation.
And there will also be questions, and we'll come to them a little later, over how the commission is split, or who has a right to part of the commission.
You know, there's a class action lawsuit about how that commission split going on right now. It's derived out of Chicago. Major lawsuit going on, and it could change the whole MLS structure.
Okay, so in the listing agreement, it's printed in black and white, but it's not really binding on the consumer. They can change it any way they want if the broker will agree to it as well.
Yeah, it's arm's length negotiation. It's not a contract adhesion, but it's very confident that a broker is going to walk if you change too much, although you and I did a previous CLE on how you should change it and you should negotiate it because you're giving the broker a lot without understanding what your rights are.
And there are some blanks. So in terms of filling in the blanks, the amount of commission, the time of the exclusive listing, when the listing agreement would expire, those are all negotiable.
Not only are those negotiable, but for a seller, the number one thing I think a seller needs to do is not have unrealistic expectations or unstated expectations. Meaning, if a seller expects someone to do multiple open houses, if they don't write it in the listing, it's not happening.
And if they're going to put a big ad in New York Times Magazine, it should state it in the listing.
So every listing is going to have a merger clause, if you really check it out, that says no prior representations are guaranteed unless it's in the listing.
Exactly.
And so they better put in, you agree to put this, not just in the New York Times, because you'll end up with one line in the classified section. You're giving me a half page in the New York Times on July 4th weekend. Like, you better write that.
And if they say they're going to do it, it doesn't, the broker says, don't worry, you can put it in the agreement, and then, if they don't sign it, that's a red flag right away. So
I like to tell my clients, I'm a practicing attorney, I mostly litigate actually, and I like to tell my clients that when you ask for something in a contract, you don't necessarily need it. It just tells you what the other side's planning on doing. So when they say no, you can still go forward. You just know that they were full of it when they said they were going to do it in the first place.
But again, it could be a red flag. You want someone to go provide maximum service, not minimum service.
When you say maximum or minimum, while I agree with you in the macro, there's many townhouses that my clients represent in the city that actually wanted to keep it much quieter and wouldn't want it in the New York Times. You're selling a $50 million townhouse. You don't want the world and their brother knowing about it. So it just depends on the fair market value.
And in terms of publicizing it, that should also be clearly stated. Is it automatic will be on the multiple listing service, or the reasons why the client or the broker may not want it there?
So there's definitely reasons the client may not want it there. There are reasons the broker may not want it there, but it's really not up to the broker. And we're talking mostly in Long Island right now, as New York City has a completely different system through the REBNY. But if it's Stratus MLS, the multiple listing service you and I are talking about, they call it a exclusive, which is known as a pocket listing or an office listing, but the system calls it an exclusive if we're not going to put it on the multiple listing service. And as I said before, some well-known people, sellers, some well-known high-end properties don't want it in the MLS for privacy reasons. So you see it both ways. You asked me a question about the advertising to guarantee the advertising, but I want to give it the other way. If you don't want the advertising, you better write that too.
As well as also a open house for brokers. You may want that or you may not want that.
You just said a very fascinating term, and I want the listener to be clear of what you said. I used the word open house before, and you said an open house for brokers. And just so the listeners understand, open house for brokers is designed to sell the house. An open house for the public is designed to allow the broker to use your house to brand themselves to get other prospects for other properties of buyers. Now, it's possible they'll sell it at a public open house, but a broker's open house is really where a broker's trying to push the house. So what happens a lot of times is, and I said about the high-end properties, I get a $50 million listing. I may have a public open house with no intent of ever selling it, but to show public buyers in that price range, look, I'm in that category.
Should the seller have their lawyer review the listing agreement or at least to fully explain to them what rights they're giving up and what rights they're firming up?
So you told me to come here by driving down hospital roads. That's a good statement, because I think you're clinically insane if you don't have your attorney review the listing agreement. If we're dealing with $1 million house and it's a 6% listing, that's a $60,000 contract. If I told you were doing a $60,000 contract with anyone else and you ran a business, you'd have your lawyer look at it.
But the broker is not going to suggest that.
The broker's not going to suggest it, and your real estate attorney is going to be in a predicament to review it, and I'll tell you why. I'm not a closing attorney. My law firm, Lieb Law, has closing closing attorney, fabulous, Steve Ciliato, but most closing attorneys have the relationship with the broker. So they don't want to undercut the spoon that feeds them. So generally what you'd want is to get it reviewed, but there becomes that catch-22 that the brokers get the referrals to the attorneys, and then the attorneys don't want to tell the brokers why their client shouldn't do the deal.
They don't want to bite the hand that feeds them.
You got it.
Is that one disadvantage to not using an attorney the broker recommends?
I don't know if it's a disadvantage in the actual transaction. I think there's a lot of advantages of the broker and the attorney having a great working relationship, and they can hit them from different angles to negotiate and strategize and work together. My response to you is I think it's a disadvantage pre-listing. I think a seller should look at two different transactions happening. One with their broker, the second one with selling the house.
And what do you mean by that?
I think it would be a good idea, behoove to sellers to see an attorney first, and then maybe not even use that attorney when selling the house, but use that attorney for a small review. I don't know how much your firm would charge. It's a one-pager. So I imagine you could get it for under $300-$400, someone to look at their listing agreement and advise you before you list the house.
And what's the advantage of going to a different attorney afterward?
Because I would want the attorney to be... Attorneys are interesting cats. So some attorneys are deal makers and some attorneys are deal breakers. And the first attorney is looking to protect you. The second attorney is trying to help it close. My biggest reason why I personally don't do closings, and Steve's so much better at it, is you need to be able to be pliable and keep a beating going and still make it close and find solutions.
And some real estate brokers would say that some attorneys are very inflexible and are deal breakers.
They would say most attorneys are. So I would want an attorney that's dealing with the broker to be very collaborative, very personable, very friendly. I write for Dan's Papers, and I just wrote an article that's going to be published soon. I don't know if your listeners know Dan's Papers, the biggest publication in the Hamptons. I wrote an article called How Do You Know If Your Attorney's Terrible? And one of the things we talked about is, do they have charisma? And if you're dealing with a broker, you want an attorney that has charisma. If the broker doesn't like the attorney, if the surveyor doesn't like the attorney, if the title people don't like the attorney, you're not going to find solutions, and little problems will become big problems.
But you want a real estate broker with more charisma than the attorney, because they have to sell your property.
I would say you definitely want the broker to have charisma, but you want the broker not to be having an affront with the attorney. They have to work together. Collaboration is key. So back to our original question, the first attorney is adverse to the broker because the first attorney is advising us the listing agreement. The second one's a partner with the real estate broker, and I don't know if you can go from adverse to partnership and keep that suave going.
So in most cases, most people are going to give the broker an exclusive listing, but also require them to put on multiple listing service?
Most people are, and I just want to echo our prior conversation. Most people are penny smart and pound foolish. So most people aren't going to hire an attorney for a half an hour. Let's say you have a $400 hourly rate. It's $200. Most people won't spend that $200 and sign a $60,000 contract with the broker because they don't want to spend the money. So that most people aren't going to do that first thing you and I are saying. But on the high end, you got to be out of your mind if you're selling a $10 million house and not having an attorney review it.
Just to understand what it means and what rights what your obligations are and what the broker's obligations are under the contract.
My biggest thing back to you is that merger clause. I want an attorney that's going to write out that it's enforceable, that the broker has to do A, B, C, D by these dates. And if they don't do it, then they're breaching the agreement.
And this is true for general consumer contracts. Whether you're buying a car, you're getting a home improvement, you should have attorneys review all those contracts, and any representations must be in that contract.
100%. Home improvement contracts is an even bigger issue, and we could have a whole nother show completely about that. There's laws about what needs to be in a home improvement contract, and the biggest thing is when you're dealing with what finishing materials, what deadlines, what are installment payments. We don't need to do that now.
And but in terms of canceling the agreement without consequences, is there
no chance?
No chance, unlike some other consumer contracts?
Well, let me tell you why. If I got an exclusive right to sell agreement, and that's not how they all are, but that's the majority, an exclusive right to sell means if my brokerage firm sells your house, we get paid.
But I'm saying, is there a cancellation
I'm explaining why
within
there's not.
A few days?
I'm explaining why there's not. Because an exclusive right to sell means if my brokerage company sells the house, we get paid. But if another brokerage company sells the house, we still get paid. And if you sell the house yourself, homeowner, we still get paid. So if there was a right to cancel it, wouldn't every homeowner cancel it when they were selling themselves?
So that's something else, and we covered it on our prior show. If you have relatives, if you have contacts in the community or neighbors who may or may not want to buy the house, you may want to write in a provision for the broker to get a lesser commission if you are finding the buyer.
I like everything you said except for the homeowner shouldn't be writing in. They should be hiring an attorney to make sure it's written in.
But if it's not in, they're locked into the higher commission, even if they find a relative or neighbor who knows someone who wants that house.
So this is me being my kindest self because I represent the brokerage companies in pursuing these commissions, and I see homeowners that write it in themselves, and they don't know how to write like a lawyer. And I will find a way around it, and I will make sure they pay. So I'm telling you, homeowners that are listening to the show, if you don't want the broker to win the lawsuit, which we will win because you don't know how to write it, you better hire an attorney to make sure that exclusive list or that reduced fee list is in.
And there are fights between sellers and real estate brokers and between real estate brokers all the time.
I have a career based on that.
And we'll talk about what constitutes a sale later in the program.
Sure.
We're going to take a short break now. We're continuing our discussion on ethics concerning real estate brokers. Lawyers can earn CLE credit by listening to the show. This program is presented as information only to consumers, brokers, and also lawyers. You should get advice from your own attorney about the many issues we've discussed. You're listening to 90.3. The voice of Nassau Community College, and also over the internet at nccradio.org. We'll be back in a moment.
This program is brought to you by Nassau Community College, which offers a paralegal studies program. Students can major in paralegal studies while earning their associate's degree, or earn a paralegal certificate if they already have a college degree. These programs can even help you start a second career as a paralegal. It's a program for anyone who wants to work in a law office assisting lawyers, the government, or a position in an insurance company. More information about full-time, part-time, days, evenings, weekends, or online courses is available by calling 516-572-7774 or by email at paralegal@ncc.edu.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau. Welcome back to Law You Should Know. My guest is Andrew M. Lieb. He's an attorney practicing in real estate and several other related areas. He also lectures to and educates brokers so they meet and maintain their licensing requirements, and he's an expert in the real estate field. We've talked about some of the issues of the seller versus the broker, and assuming that that agreement is signed, some of the responsibilities that should be outlined, and just you explain under what circumstances a seller may or may not want an open house. Well, and what about staging or valuing the house? Is that something? Is there when a broker is asked to establish a selling price or a listing price? What are the ethics involved in that?
I love that question. Let's start off with the establishing a listing price, and then I'll do the staging because there's two different questions there. A broker does not give an appraisal. Let's just say that one more time. A broker is not licensed to give an appraisal. There's actually two different appraiser licenses, a licensed appraiser and a certified appraiser. I've taught appraisers as well. Brokers cannot do that. What brokers can offer is what's called a broker's price opinion. Notice the keyword opinion there. So they're giving you an estimate, and when a broker does a BPO or broker's price opinion, what they're doing is a loose comp analysis. And what a loose comp analysis means is they're finding comparable properties in your block, and they're seeing what they traded on in about a 6-month period, and they're telling you the answer.
And making adjustments for your property.
So when you just said adjustments, I want to go back to the word loose that I used. And they're making loose adjustments, whereas if you had an appraiser do it, they would be saying, you have 10 years left on your furnace, that house has 20 years left.
It's also still more an art than a science.
It is, but the art is much more exacting when an appraiser does it. A broker is doing much more of an opinion. So when I do a court case, because I'm a litigator as well, I would never, ever in a million years have a broker do a BPO as an expert witness, and they wouldn't qualify.
And a seller could pay a few $100s to have a licensed appraiser
100%.
value it, and that might be help to sell the house, especially if you're selling it a little bit below to move the property.
Well, I'll tell you when the license appraiser really comes in handy is when you deal with a mortgage contingency clause. A lot of the times the house won't appraise and the buyer will be able to back out. A smart seller that accepts a mortgage contingency clause should ask the buyer to assign the right to challenge the appraisal, because a buyer can challenge the appraisal. Now the seller can challenge it by hiring their own appraisal to say, yes, it did appraise.
Should a seller consult a couple of brokers so they get their ballpark comps?
I don't
See
know
how they come out.
I think it depends where they live. Like you said, should they consult a bunch of appraisals? It depends how tech savvy they are now too. Like in the age of Zillow or MLS, when you're going online, I kind of know what every house is worth everywhere. When I say it depends where you live, if you live in a Levitt house is you kind of live there. If you live in Kings Point, they're very unique on every house, and then you might want to consult different brokers.
And is it good to use the local broker?
I think that it's good to use a local broker if you're in a local community. And what I mean by that, one more time, is in Long Beach, I think using a local broker is a great idea. If you're in Kings Point, you may want to be using a Manhattan broker or a broker that has a Manhattan footprint as well, even though they're a local brand, because you're going to be attracting people moving from the city that are CEOs and the like.
And buyers are probably going to look for a local broker.
So they're going to look for a local broker on a local house. So let me differentiate where we're going. You're asking, should they use a local broker? Most people don't hire the broker. They hire the licensed real estate salesperson or the associate real estate broker. And they go with a broker, which is the company, like a Douglas Elliman Real Estate's a broker, a Daniel Gale's a real estate broker. Tommy Smith, who whatever, isn't the broker. He's the real estate salesperson. So I would want to use a local licensed real estate salesperson or a local licensed associate real estate broker. And I might use a local real estate brokerage firm if it's a local community like a Long Beach. But if I'm in a Kings Point, if I'm in a Sands Point, if I'm in a Brookville, I want a national footprint or at least a regional footprint, because I want that marketing to hit other places like Westchester and New York City and the Hamptons and the North Fork. It just depends on where you are and the type of market you're going for.
You mentioned it earlier, and what is the broker under an obligation to stage the house, or if it's written in the listing agreement, or they'll sell it as an upsell?
Well, you asked about staging, but you asked a question before as well I want to hit before I even hit staging. You asked me about ethics, and I just want to be clear about my answers. When I'm answering you, I'm answering from New York State's license law perspective. But we keep talking about something else that's a big confusion in our industry. You've probably watched Modern Family and heard, I'm a realtor. Well, what's a realtor? So a realtor just means they're a member of the National Association of Realtors or a local chapter, being LIB or the Long Island Board of Realtors. They have additional ethics rules, and their MLS, the Multiple Listing Service, which is a sister company, has MLS rules. Now, those aren't really ethics rules or MLS rules. They're just contractual agreements between brokerage firms. So when you ask about staging, I'm going to answer you as to New York State, really, because I don't want to go to the different clubs. The answer is that aren't they doing interior design without a license? It's a great question.
But if they give you advice on cleanup or putting the house in the best possible shape, just to save the cost of a decorator or a professional stager.
I love the way you just said it. If they give you advice, and that's exactly the answer. I've actually written an article about where the line goes. They shouldn't be buying you furniture. They shouldn't be doing construction.
Yeah, they can give you some
advice,
do's and don'ts.
Tips, pointers, and any good broker is going to give you good pointers, because a room that was, I love this. You probably see this in the market. It's refinished. It's new. It's new from 1980. A lot of people forget that the fact that they redid their house since they bought it doesn't mean that they redid it in the last 2 years.
And maybe if you add brand new, it means something else.
Well, we'll find that one out. So I think that, to answer your question, 100% staging's a must, although I will tell you, and I said I'm going to answer from the Department of State, we tried to do in my school, Lieb school, we tried to do a staging course years ago. It's the only course of the 30-something courses we've ever submitted that was denied. And it was denied because the Department of State said they do not think it's a real estate broker's obligation to understand staging. We brought the course under the theory of caveat emptor, let the buyer beware, which, as I'm sure you know, a broker, a seller's agent, a seller, a broker, a seller's agent, a seller, is not liable for any problem in the house. if an ordinary buyer through ordinary diligence could have discovered the defect absent active concealment. So when we talk about staging, you can't put a picture over the mold spores, and that's what we tried to teach.
And does that apply to other things about property taxes, building a railroad next door, or a factory or something?
100%. I'll give you a good story.
Or environmental issues?
Perfect. I'll give you a great story. So we actually did this lawsuit recently. Someone was suing my client because they said, you said that this was on the 5th floor, and I might be wrong on the floors. It was a high-rise in the city. And they said, you said this was on the 5th floor, but it's really only the 3rd floor of the building. And our motion to dismiss said, our client has eyes. So when you can figure this out on your own, you can't sue the broker. And this is a big misconception. Lawyers out there, you're taking stupid cases, and someone's going to write you a letter that says this is a frivolous application, and they're going to move for sanctions when you do this, because there's no way that you can sue a broker or a seller for caveat emptor. Because of a caveat emptor, if your buyer could have discovered it through ordinary diligence.
So it's up to the buyer to do their own research and due diligence, whether through their lawyer or through someone else, to find out if the house had an oil leak, or there was a gas leak at the ex-gas station on the corner, or the dry cleaners, or anything along those lines.
Well, you just said something that I want everyone to hear. What does a buyer's attorney do? That's really the question, because a lot of people go, they do the closing. Do you do closings? We in attorneys call it transactional law. Brokers say, are you a closing attorney? A monkey could probably do the closing. What a buyer's attorney is doing is they're confirming that the representation the buyer's agent and the buyers had when they made the offer are true through doing due diligence and using exculpatory clauses in the contract of sale to get their client out. So you really want to listen to your buyer's attorney, and you want your buyer's attorney to be worried about oil issues, like you said before with Navigation Law 181. You want your buyer to be checking the survey with out-of-possession issues. They're clearing title. That's what's going on.
Okay, this about brings us to the end of the first part 1 of this CLE program for lawyers, and on the broadcast you'll hear it next week, which will be part 2 that will pick up where we're leaving off today. So the code for attorneys is LIEB 101. And that's the code you need, CLE, given by the Nassau Academy of Law. You can contact them at 516-747-4070 to find out their procedures, or look at nassaubar.org. And again, the code is LIEB 101. If you missed any part of this program, it's available as a podcast by going to nccradio.org. And, of course, you can look on the website for Andrew M. Lieb about any of his programs he offers to brokers or to large agencies or small real estate firms. I'm sorry.
I was just liking your
and also his website. And we hear more about real estate and all the topics we've been discussing on part 2 of this program. You're listening to Law You Should Know, the Voice of Nassau, on the Voice of Nassau Community College, 90.3 WHPC, and also over the internet, nccradio.org.